Good morning. Today we are going to discuss vicarious liability. Vicar, V-I-C-A-R, vicar. Vicar means substitute. Vicarious liability means when you are not liable for what you have done. You are liable for a wrong done by somebody else. Vicar means substitute, who performs the functions for another. A substitute is one who does something for others. Therefore, the concept of vicarious liability has come into existence. If I am doing your work, then I am not liable for that. You are liable because you have appointed me. What Salmon says, in general, a person is responsible for his own acts. He is not responsible for others' acts. However, in exceptional circumstances, you are liable for the wrongs which are done by somebody else. However blameless you may be. You may be blameless. You may be not liable for anything. But law says no, you are liable here. Because the other person is related to you by some way or the another. So, general rule is that you are liable for your own torts. However, sometimes you are liable for the wrongs done by somebody else. That somebody else is your substitute. He is doing the things because you have told him. He is doing the things because you have appointed him. We are going to see those modes or those relationship also where vicarious liability exists. So what is vicarious liability? Vicarious liability means you are liable not for what you have done, you are liable for what the things which are done by somebody else. Now, the concept of vicarious liability is based on some principles. 3 principles are there. The first is qui facit per alium facit per se. Qui facit per alium facit per se means if you have appointed somebody else, then you are liable for whatever acts are done by him. He who does an act through another does it himself. So this is the base of your agency. Principal appoints the agent. So principal is doing the acts through another. So in law, he himself is liable. This is the first principle on which vicarious liability is based. Qui facit per alium facit per se. The second is respondent superior. Respondent superior means let the higher authority be responsible because that higher authority has appointed you. There is a legal presumption that servant does acts only on the master's order. Now if the servant is doing acts on master's order, then master is liable because he is the superior. So let the superior be liable. This is the second principle. And the third recent view is that when you are doing your acts through another, you should be liable. Not that other person, because that poor other person, what he is doing? He is only following your orders. So when a person does something through another, then the person himself is liable vicariously. Like when the servants, the public servants, you can say public servants are doing some acts in their official capacity and some tort occurs by them, then the government is liable because the government is their master. So master is liable for the acts of the servants, authorized acts of the servants. These are the 3 principles on which vicarious liability is based. Qui facit per alium facit per se, respondent superior, and the recent view is that when you do some act through another, you yourself are liable. That is a rational view because the servant should not be made liable for whatever he has done for the sake of his master. Now, vicarious liability can be created by 3 different modes. The first is ratification. What is ratification? When an unauthorized act is made authorized, that is called as ratification. See, we'll take an example. I have told you to do certain things. certain things, will take example like 3 things I have told you. I have told you to do 3 things. These 3 things are authorized. As you are doing those things for me, I'll be liable under law vicariously. But when you do some 4th thing, that 4th thing I never told you, so that is unauthorized. I'm not telling about illegal or unlawful act. I'm telling about only unauthorized act. You have done that 4th act which is unauthorized, and you have come to me and you are telling me, you apologize to me and say, this is the last time, you are not going to do any unauthorized things hereafter. So what I do, okay, I say, okay, this time I forgive you, I accept what you have done. So the 4th thing which was unauthorized, I accept it. Once I accept, that is called as ratification. Once I accept, that unauthorized things becomes authorized. So when the unauthorized thing is made authorized, which is legal, lawful, everything you have told to me, then only I am going to ratify. Then I am liable for that. I am liable for all those things which I have authorized you to do, and also I am liable for all those things when I ratify your unauthorized acts. So through ratification, vicarious liability comes into existence. The second is abetment. Abet, A-B-E-T-M-E-N-T, abetment means when somebody provokes or encourages. If I encourage you to do some tort, then I am liable. I am telling you to do certain things. Now I am provoking you. In crime also, abetter and the offender, they are treated at par. They are treated at equal level. Both are liable. Abetment is an offense. Here, abettor is abetting the tortfeasor to do some tortious act, to do some wrong. He is provoking him. He is instigating him. He is helping him, aiding him. So the abettor is liable. Abettor also comes under vicarious liability. That is the second mode for creation of vicarious liability. And the third is special relationship. There are 6 different relationships where vicarious liability exists. The relationship is such that vicarious liability is there because one is appointed by the other. There are 6 different relationships where vicarious liability exists. Master is liable for Servants Act. The firm is liable for Partners Act. The company is liable for its Directors Act. The owner is liable for Independent Contractors Act. Sometimes independent contractor is liable for his servant's wrong, but sometimes the owner is liable. We will see this in another video, the relationship between the owner and independent contractor. Here just you consider that sometimes owner is liable for the tort committed by the servants of independent contractor. That is the 4th. 5th is guardian and wards. That is whatever the children do for that, their guardian are liable. And the 6th is the principal and agent. That is, the principal is liable for the Agents Act. These are the 6 different kind of relationship: master and servant, firm and partner, company and director, principal and agent, owner and independent contractor, and guardian and wards. That is the parents and children. See, for certain times only the parents are liable or the guardians are liable. Guardians are not liable for all wrongs. Only when the guardian or the parents are negligent, then only they are liable for the Wards Act, the Children Act. And when the child is acting in a particular circumstances as their agent or their servant, then only parents are liable. I will make it clear. Parents are not liable for the acts of their children generally. However, in 2 cases the parents are liable. When parents are liable? When they themselves are negligent, because of which their child does some tort, then parents are liable. And when the child is acting in that circumstances as a servant or as an agent of their parents, then only the parents are liable. We'll take one case, Newton versus Edgar Lay. In this case, what the father does, negligently he keeps a loaded revolver on a table. His children are there. One of a child picks that revolver which is loaded, and he shoots one person. Injuries are caused. Here the master, in a sense the father, is liable here, as he has done some negligent act. As he is negligent, whatever his child does, the father will become liable. Okay, now these are the 6 kind of relationship. You can say these are special kind of relationship where one person in a position of a master, he is liable for the other person. He may be a servant, he may be a partner, he may be a director, he may be an agent, he may be a contractor, or he may be a child. On the other side, the superior authority is there. The master, the firm, the company, the owner, the principal, the guardian, some superior authority is there. Therefore, he is liable. Vicarious liability exists here. Okay. Bye bye. See you in the next video.